For the past 3 decades, as our lineup of speakers and events for 2015 reveals, the organizers of this program have maintained a commitment to commemorating the victims of the Holocaust, using education as a tool to combat prejudice, and promoting ongoing awareness about genocide. And for the past 3 decades, the program has made a commitment to inviting outstanding scholars who are doing important and innovative work in their fields to visit OSU and share their research. We've had a great luck in recruiting superb scholars, and tonight's speaker is certainly continuing that tradition. Dr. Elizabeth Heineman is a professor of history and the chair of the history department at the University of Iowa. She is a historian of modern Germany, as well as a historian of women, gender, and sexuality. She is the author of 2 books, including What Difference Does a Husband Make?, an examination of gender and marital status in Nazi and post-war Germany, as well as Before Porn Was Legal, a history of the erotica industry in post-war Germany. She's also the author of numerous articles and chapters examining sexuality, motherhood, and gender identity. Her work is pioneering and fascinating, and an invaluable resource for scholars working in multiple fields. Most recently, she edited and published the 2013 collection, Sexual Violence in Conflict Zones, From the Ancient World to the Era of Human Rights. Tonight, Dr. Heineman will be speaking on the topic of human rights law and the issue of violence against women. Please help me in welcoming Dr. Elizabeth Heineman to Oregon State University.
Thank you so much. I'm really, really grateful to the organizers for bringing me here. It's been really wonderful to see the very impressive programming that's been going on over the last 29 years, and particularly the student conferences this year. It just speaks to a kind of a dynamism of scholarship, community work, student work in various kinds of disciplines and practical fields as well. So this is just terrific. I'm delighted by the dynamism of the community here. The material I'm going to present today comes from some collaborative work that I did over the past several years with human rights historian Joe Butterfield. And I want to start out simply by acknowledging that this is collaborative work and noting that the actual original part, the more original parts of what I'm going to be talking about are actually Joe Butterfield's work and not my own. It's been very interesting for me to work collaboratively. Historians don't usually do that. We don't usually co-author articles. That's much more common in other disciplines. And this collaboration came out of a larger collaborative project on gender and armed conflict that's based at the Transitional Justice Institute at the University of Ulster in Belfast. And they're basically working towards a big book on gender and armed conflict that really is aimed to inform practitioners more than academics. And the larger team consists of roughly half academics in legal studies, anthropology, political science, economics, and people who are sort of working in the field, people who work with NGOs, people who are on the ground in refugee camps, working with gender and armed conflict and its aftermath. I was brought in as the token historian. And in this context, asked to provide, in their words, a historical survey of women in war. You have 20 pages. Upon further discussion, it became clear that they really didn't want to limit it to women because obviously men as gendered beings are quite present in the history of war. So it became Gender and War, historical survey, 20 pages. And of course, this is the kind of assignment that only a non-historian would come up with. But having said that, lacking the filter for assignments to which I should just say no, it seemed to me that this was a really interesting challenge. Clearly, doing a genuine survey was out of the question, but the task at hand, really, the meaningful task at hand, was to figure out how to say something historically that wasn't kind of dropping a plumb line. They didn't want 20 pages on sexual violence in the European theater of World War II. right? That would be a historical study, but too narrow. They needed something bigger, and they needed something bigger that was going to help to inform the people who really do have very present-day oriented interests. And we didn't want this to be the chapter that everybody skipped to get to the stuff that mattered, the dutiful historical chapter. So Joe and I felt very strongly that we needed to tackle some specific question of urgent relevance today that people out there in the field are grappling with, but something that really could be best addressed, or at least productively addressed, through a broad historical overview. What we ended up with was looking at what is really a knotty, K-N-O-T-T-Y, problem for present-day international feminist activists. And that is that in the arena of thinking about violence against women in armed conflict, there have been significant advances in the world in developing international law. And I'll talk a little bit more in a moment about some sort of signposts of that advance. There have been some really major achievements in the world of international law in terms of violence against women in armed conflict. In the arena of violence against women in non-conflict settings, there have been an awful lot of disappointments in terms of the international law arena. Now, I am going to be focusing here on law and binding institutional structures, and I'll explain that term in a moment. And of course, it's important to realize that passing a new law does not mean that everybody automatically changes their behavior. We do know that. It doesn't mean automatic improvement on the ground. But it does help you get a sense of where you're getting some traction. If you've got a big international feminist coalition trying to convince international bodies to create a binding statement, binding practices on something or other, and you can't get them even to make that statement, that tells you something, right? So if you've got this coalition working and you can get international institutions to create new expectations, that tells you that at least you're getting some traction. It does not mean overnight change on the ground, but there is, again, we see many instances of cases where you've got coalitions saying, listen, can we have a strong statement condemning violence against women in the family, for example, and you can't, okay? Again, that's a kind of an alarm bell. So let me give you sort of two examples. These are maybe one in each arena: violence against women in settings of war and in non-conflict settings. So you have an understanding of what kind of arena we're talking about here and why there's a sense that there's been some progress in the one and a lot of disappointment in the other. In the arena of violence against women in situations in armed conflict, and particularly sexualized violence against women, probably the sort of landmark event is the creation of the International Criminal Court and the so-called Rome Statute that created the International Criminal Court in 2002. The Rome Statute that created the International Criminal Court codifies a prohibition against sexual and gender-based violence in war. Now, it's the International Criminal Court's job to try war crimes. You think about, say, the Nuremberg tribunals after the Second World War, the Tokyo tribunals after the Second World War, or various tribunals more recently in places like Sierra Leone, for example. There's a practice of having tribunals after wars, but they've tended to be ad hoc, case-by-case arrangements. And the idea in creating the International Criminal Court is to have a permanent institution whose job it is to deal with war crimes after wars across the board. Anyway, in the Rome Statute that created the International Criminal Court, you have a codified prohibition against sexual and gender-based violence in war. The Rome Statute also includes what I'm calling here binding institutional structures. And what that means is that as the court goes about its business, there are certain rules about how it has to, for example, collect evidence, needing to provide protection for witnesses against retaliation. It's one thing to sort of say, the court is going to try these kinds of crimes, but you need to have procedures in place to make sure that those trials could be effective. And that means doing things like providing protection for witnesses, understanding that when you collect evidence, you have to go to certain kinds of communities to do so. So that's what I mean by binding institutional structures. And binding, these are not recommendations, they're binding. On the basis of this, the International Criminal Court produced relatively quickly both indictments and convictions of cases of sexual violence in settings of armed conflict in the wars of the former Yugoslavia and in the Rwandan genocide. So it's been an effective institution in at least making, sort of very powerful claims for what is and is not acceptable in warfare. In the arena of violence against women in domestic settings, in non-conflict settings, the signal disappointment, we might say, is what's called the Convention for the End of All Forms of Discrimination Against Women, CEDAW for short. CEDAW for short. And again, this is just kind of a tip of the iceberg kind of issue, but I just want you to have some vocabulary on each side. The Convention for the End of Discrimination of All Forms of Violence, of all forms of discrimination against women, the Convention for the End of All Forms of Discrimination Against Women, CEDAW, passed the UN General Assembly in 1979. It was ratified by the prescribed number of member states in 1981, and so it becomes binding. And CEDAW is pretty far-reaching in terms of what's in the text. I mean, it really does have a lot of pretty powerful provisions. What happened, however, is that almost all UN member states have signed it, but a very large number of member states signed it with reservations, and reservations are kind of a UN convention. You can sort of sign off something with something and with a little parenthesis saying, except for paragraph 17, number 2. And what that's supposed to mean is that, if there's a very particular provision there, for example, let's say that overlaps with some other treaty you're bound by. You're a member of the EU, for example, and you've signed off to something on the EU that addresses the same issue, slightly different way, but you're already bound by that. So you just sort of say, on this item, we're going to just go with the EU provisions that we've already agreed to. That's considered fine. What's happened with CEDAW is a very large number of states signed off with reservations that completely undercut the treaty entirely. So, for example, we're signing off for the treaty, parentheses, except for the provision that require us to reform our domestic legislation to eliminate discriminatory provisions. Okay? Or except for the parts that require wives to have equal rights to their husbands. Think about family law. What's disappointing is that many states signed off in this fashion, but equally disappointing is that the UN has permitted it, right? That they've not sort of turned around and said, that kind of if you're going to have that kind of reservation, you don't get credit for signing, right? So, these are single pieces, single very big things happening in each arena. The non-conflict arena with CEDAW, the conflict arena with the International Criminal Court. Obviously, these are single examples, but they kind of signal what seems to have been a larger pattern. How do we explain this discrepancy? I mean, one important factor is national sovereignty. The United States has not signed off on either the International Criminal Court or CEDAW because of the United States' kind of long-standing troubled relationship with the UN and the notion of handing over any element of national sovereignty. So that's always been an issue, particularly with the United States. But more broadly, there is a greater acceptance of some international oversight of interstate issues, such as armed conflict between states, than international oversight of issues that are considered purely domestic. Okay, so that's a very important piece of this history. Joe and I, however, found ourselves focusing on a second issue that helps us to understand the difference. And that is the privileged place of armed conflict in defining citizenship. We were very concerned with the category of citizenship and the citizenship, which we often think of at the national level. You're a citizen of one country or another. But obviously, the international arena is in part concerned with some notion of international citizenship, right? Rights you have regardless of what state you live in. And what we found is that women's strivings for full citizenship in international frameworks have seen greater success when they concern armed conflict than when they concern other issues. And that ties to a long history of a kind of a complex of gender, armed conflict, and citizenship. which is what we then ended up focusing on in trying to create a kind of a longue durée history. So today's talk, I'm going to sort of drop plumb lines into kind of 3 moments to move us through this longer history. I'm going to start back in the 18th century, which is where we see the emergence of modern theories and practices of citizenship and how they're entangled with both war and gender. Okay? Think American Revolution, French Revolution, right? The emergence of modern citizenship. Second, I'm going to jump to the second half of the 19th century, where we start to see the emergence of frameworks of international law that concern us. This is not the, there's been international law already for centuries regulating things like trade. I'm not concerned with that. But in the second half of the 19th century, we start to see the development of what's going to become 2 very important international legal frameworks: international humanitarian law and human rights law. Human rights law was privileged in the title of this talk, but humanitarian law is equally important. Humanitarian law evolves late in the 19th century, and human rights law evolves after World War II, much later, much more recently. And then third, I'm going to move to the late 20th century, where we see international feminist organizing around both international humanitarian law and human rights law, and sort of see what kind of effect international feminist organizing has had in the development of those. All right, so let's crank ourselves back to the 18th century. Before the so-called Age of Revolutions in the late 19th century, we see a kind of a gender war nexus. Obviously, in the history of warfare, it's basically men bearing arms. So there's an association of men and armed conflict. Citizenship, however, is not part of this nexus, because the sort of modern notion of citizenship isn't there, and the notion of sort of fighting for your country, this sort of national identification, is something that really evolves in significant measure through these 2 generations of warfare. So what we're going to see in the late 18th and early 19th century is an evolution of a gender war citizenship, sort of threefold complex. The so-called wars of revolution and liberation are 2 full generations of warfare. We think very often of, the French and American Revolution, and we also recognize that even before those revolutions, there's a kind of an intellectual history of the Enlightenment, the notion of the rights-bearing individual. But citizenship in practice emerges in these wars. 2 things we don't always think about when we think about those wars are the massive scale and diversity of those wars. It's not just the French and American revolutions. During this time, you also see revolution in Haiti, which is geographically a small place, but it's basically a slave revolt that then turns into a battle for national independence, and you end up with a republic led by emancipated slaves, or slaves who have basically emancipated themselves. So it's a small place, but it has enormous ramifications. The ways that slavery and freedom come into this fight for liberation. And we also see all of Latin America. By 1830, a dozen new countries in Latin America have sprung up, right? So we're really talking about a 2-generation period from 1775 to 1830, 2 full generations of transatlantic warfare, bringing in European populations of European descent in the Americans, enslaved populations, free blacks, indigenous populations, enormous diversity of populations, and also very, very important, conscription, massive conscription in many settings for the first time. Previous to this, in European warfare and in warfare in European colonized areas, particularly in the Western Hemisphere, again, you hadn't had mass conscription. You basically had kind of an aristocratic officer class that lent its loyalty to some dynasty or other, an emperor or a king, right? And then they hired mercenaries, right? But this business, now that we've got this sort of 2-generation period of fighting for the freedom of your country, right, for independence from colonization, or in the French case, overthrowing the king and beginning a republic, there's a much deeper sense of fighting for your country, this connection to your country rather than a dynastic leader. And it's associated, of course, with citizenship. What's the whole point of gaining your independence, right? There's going to be a concept of citizenship here. what happens over this 2-generation period of warfare is that in a huge chunk of the world, military service comes to be understood as the patriotic duty of all men, who are now understood to be bound to their nation. It doesn't mean that there's 100% conscription, but it means that all men might be called on. Okay? If you are a man of your state, you might be called on to defend that state. Okay? Where you have newly constituted citizens, so in a place like the United States where you have the concept of citizenship, citizenship is tied to your ability to be available for military service. Now, many states emerged from this period not as kind of republics, but you still have sort of very strong monarchs. But even there, you have an increased notion of being a patriotic duty to fight for your country, sometimes with the promise of citizenship sometime in the future. Or for slaves, for example, the promise of citizenship. If you take up arms, then you will be freed and you'll become a citizen. What happens is that over this 2-generation period, we sort of come out of that period with this kind of 3-way complex: gender, armed conflict, and citizenship being tied to your nation. Now, how do women fit into all of this? Of course, women are very much involved in these massive wars. They make a lot of contributions. They pamphleteer, they provide economic support. Very large numbers of women provide logistical support. They're so-called camp followers. So they really are kind of traveling with the troops. This is still pre-industrialized warfare. And they're traveling with the troops, and they're doing the laundry, and they're doing their cooking, and bandaging wounds, and so on, and sometimes ending up in the line of fire. Nevertheless, with very few exceptions, women are not bearing arms in these wars. What ends up happening then is that you have this sort of emergence of this notion of citizenship, of loyalty to a country, in which women have a very awkward role. And the question of how women fit into the citizenship paradigm is really one of the foundational problems of the late modern era. This is a really tricky question because they're involved in warfare, but they're not involved in the same way. They're going to be citizens, but they're not going to be citizens in the same way, right? So this is a really tricky question, right? And obviously this is going to set off many generations of feminist struggle, women's not having full citizenship. Let me say a couple things about the term citizenship. It can mean a lot of different things. There's a notion of sort of Republican citizenship, meaning you as a citizen have a role in your governance. You can stand for office. You can vote for representatives. Okay, so you're a citizen in that you govern yourself in some way. You're part of a governing body in whatever way. You have a notion of liberal citizenship, the rights-bearing individual. I have certain freedoms, and some king can't just sort of take these rights away from me, right? So that's a kind of a notion of liberal citizenship. I have certain fundamental rights. There's a sense of national citizenship, which can be a kind of a more amorphous thing, just a sense of belonging. What nation do I belong to? But it can also come with certain rights, right? If you are a French citizen, well, you fall under that legal code, right? These things can kind of intersect in different ways. They don't always occur exactly in the same combinations in different countries. They sort of sort themselves out in different ways. So citizenship means a few different things, but they tend to intersect one way or another, and the stakes are very, very high, whichever one you're focusing on, whether it's being a rights-bearing individual, whether it's having a role in governance, whether it's fully belonging to a national community. In any case, what we have here is this really earth-shattering, 2 generations of warfare that completely changes the nature of statehood and individuals' relationship to the state. And this notion of modern citizenship is completely embedded in that experience of war, right? The expansion of suffrage over the next 2 centuries is almost always connected to war, almost always. In the American example, you have the extension of suffrage to African American men after the Civil War. Now, once people gain the suffrage, it's not necessarily stable, as we know from the history of Jim Crow America. But nevertheless, that expansion of suffrage following the Civil War to African American men, women's suffrage in many settings following the First World War, right? In the United States, the lowering of the voting age to 18 in light of the Vietnam War, And I could give you many, many international examples as well, but we have rather few examples of any meaningful extension of suffrage without a war being involved in some way. So the sort of connecting of citizenship claims to war is a really durable thing. So far, what we've talked about is kind of the gender nature of citizenship, the way it's embedded in war. You would probably get this in many good intro-level Western Civ classes, at least I hope you would. But what I want to do now is move on to the international legal framework, international humanitarian law and human rights law. International humanitarian law regulates conduct during war between states. Okay? The idea is that states waging war against each other have certain responsibilities for how they and people acting on their behalf should behave. And it dates to the mid-19th century in light of aftermath of the Crimean War, which is the first industrialized war. And you have the first Geneva Convention that focuses on the care of wounded in the field. Okay, you have wounded in the field. The Geneva Convention says you need to allow medical personnel to go there and care for the wounded, right? And then you have many, many updates, and you sort of hear about the Fourth Geneva Convention and the Second Hague Convention, and there's all these conventions that have to do basically with regulating the rules of warfare. A good framework for understanding them is an effort to shape sort of civilized masculinity in an era of industrialized war, right? Because, again, this is basically going to be a masculine activity. So, for example, if you're waging war like a civilized nation, you don't attack civilians. If you're waging a war like a civilized nation, if they're wounded out there, you allow them to be cared for by medical personnel. If you're waging war like a civilized population, once you've captured prisoners of war and demobilized them as a military threat, you treat them humanely. They are not your slaves, right? Part of this sort of notion of civilized masculinity ends up expressing itself here in a kind of a protective language. The Geneva Conventions and the Hague Conventions, but particularly the various Geneva Conventions, do start talking about the situation of women in wartime. And they speak about sexual violence against women in wartime. And what they establish, though, is not a prohibition against committing sexual violence, but rather a responsibility of states to protect civilians. So it's kind of a protective framework. Women need protecting, right? Rather than women being sort of rights-bearing subjects. Women need protecting, according to these terms. Another very common feature of the language of international humanitarian law as it evolves, again, given the sort of vexed relationship between citizenship and war and women's rights, is that sexual violence against women in war, which is named in various ways through these conventions, is defined not as a violation, not as violence against the body, but rather a violation against honor. And that's a thread you see over and over and over again in these conventions. It's a violation against honor. The thing with honor is that honor can refer to a lot of people. Maybe it's the woman's honor that's soiled, but maybe it's her husband's honor that's soiled. Maybe it's her father's honor that's soiled. Maybe it's the honor of the whole community. If a lot of women are raped, maybe the community has been dishonored. So there's a little bit of fuzziness about who exactly the victim of this crime is. Is it the woman herself, or is it the men who surround her? In any case, this protective framework speaks partly to kind of a notion of what civilized masculinity is all about. You should protect women and children. The civilized part of this is also borne out by the fact that in the era of the sort of second great wave of European empire, these conventions do not apply to colonial warfare. They do not apply to colonial warfare. And the technical reason for that is that they apply to signatory states, and regions being colonized aren't states. So what you don't have is any notion that all of this discussion is supposed to impose any restraint when it comes to colonial warfare. It's supposed to impose restraint when it comes to warfare between civilized nations. All right, so this is a very important emerging body of law as we move towards an era of industrialized warfare. With the First World War, things get shaken up in certain important ways. Of course, you have, of women in the North Atlantic world in particular making profound claims to citizenship, right? And in some cases getting them with the First World War, gaining the suffrage in many North Atlantic locations after the First World War. And this is obviously kind of a declaration following the First World War, following women's contributions, that women have a claim to citizenship. Now, at that same moment, you have the formation of the League of Nations. So you have this sort of new international arena. No longer is it just going to be about creating one treaty or another, but you have the League of Nations as kind of a permanent body. Internationally minded feminists, even prior to the First World War, everybody's working on suffrage in their own country, but these feminists know each other across state lines. They're going to international conferences. They're trading notes. So there's an international feminist movement. Internationally minded feminists show up at the League of Nations, right? And they show up and they try to participate in the debates. And they have very clear notions about an expanded notion of women's citizenship, particularly given the recent history of a protracted war. Their focus, however, was not on ameliorating the conditions of war. That is, when it comes to war, how should women be treated? That's not their concern. Their concern is how to prevent war in the first place. They do not see war as inevitable. They do not see its horrific consequences as inevitable. They feel that if women are fully integrated into the political system, then there just aren't going to be as many wars. So they want to focus on that. They are very concerned about expanding women's citizenship in order to help prevent war. Okay? So they're doing a lot of work there that has to do, again, with this kind of gender, citizenship, war nexus, with women as gendered beings as very much as part of it, but it's about prevention. Okay? Very important activity going on over here. At the same time, however, after World War I, you also have a flurry of revisions of international humanitarian law. There's just been this recent experience of warfare. Feminist voices are not at all present there because the feminists are over here working on this prevention thing. International humanitarian law people are further revising the various conventions in that regard, and they are continuing to underscore that sexual violence is an offense against honor. Okay, they're continuing to reiterate a very protective framework, okay, protections rather than sort of full citizenship for women. After the Second World War, you see, of course, the establishment of the United Nations after the collapse of the League of Nations system. And with the establishment of the United Nations, you have the creation, the emergence of the second important body of international law that I want to talk about, and that's human rights law, right? The UN is established in 1945. Very quickly, you have the Universal Declaration of Human Rights, very, very early project of the UN. And this is really important because this is the Universal Declaration of Human Rights is really about the notion of a rights-bearing citizen, regardless of what particular country you live in. You're not just a rights-bearing citizen of France or of the new state of India or of the United States or of Mexico. You are in some way a citizen, universal citizen, okay? And you have rights, okay? This is kind of a primacy of liberal citizenship. Internationally minded feminists are here for this too. Okay, they're very present in these discussions around the Declaration of Human Rights and all the other activity that the UN is engaged in. They are still very concerned with preventing war. Okay, there's another wave of new states that gain women's suffrage in light of the Second World War. You've just, again, had another total war. Feminists would like there just to not be wars anymore. They're sick of the war stuff, right? And they really, again, feel that many of us had the suffrage before, but we clearly were not fully integrated into the political system, and they weren't. We need to keep pushing this business of having women fully integrated into the political system at the national level and at the international level, and if we do that, we're not going to have as much war. Prevention is the answer. In terms of human rights law, however, they also did articulate a clear demand for women's rights as political subjects and not just objects of protection. They were very clear about that distinction in the aftermath after the Second World War. Very, very clear about saying women are rights-bearing individuals. We don't need conventions that protect women. It needs to be clear that women are rights-bearing individuals. what happens is that basically the Cold War intervenes. It doesn't just kind of come up as a distraction, but actually the discussions of what women's citizenship means are intrinsic to some of those differences between East and West in the Cold War in ways that I'm not going to get to today, because we don't want to be here all night. But what I do want to say is that we do have this articulation of a notion of women's citizenship as rights-bearing subjects in the aftermath of the war. It ends up, for all practical purposes, being tabled in many ways. As the history of the UN goes on, and particularly the human rights activity of the UN develops over the decades, you have things like the Covenant on Civil and Political Rights, the Covenant on Economic, Social, and Cultural Rights. Really, these are binding covenants for member states establishing what political rights and civil rights people need to have, what economic rights they need to have. And they still tend towards a protective framework for women, by and large. Not entirely. There's a little bit of a mishmash there. But the protective framework ends up really, again, there's a kind of durability to that. In the last quarter of the 20th century, you have a new wave, new generations of international feminist organizing, articulating new kinds of demands and analyses of women's citizenship. And as it happens, that then is going to come to a kind of maturation coincident with the end of the Cold War system in 1990. So that's moment number 3, making progress. When we think of second wave feminism in the North Atlantic world, in Western Europe and the United States, we sort of, many of us know, elements of that narrative of second wave feminism. But at the same time, there's very important stuff happening in what we now call the global South, newly independent states. And these are newly independent states that often have very important concerns having to do with development, very important concerns having to do with their very, very conflicted political and economic relationship to the global North. And you have feminists emerging in the global South, often with rather different concerns than second wave feminists in the global North. Okay? Efforts at coalition building are first rather fraughted. I mean, they're very fraught. It's difficult for people from these very different worlds to come together and sort of understand that they don't have all exactly the same concerns, and certainly those coming from the North Atlantic have been taking for granted that they speak for everybody, and that, of course, their concerns now are going to apply to women from newly independent states, and that's not necessarily the case. There are some very, very, again, very sort of fraught conversations, catastrophic conferences in the 1970s where things get very, very hard. By the time we get to the end of the Cold War, though, international feminists have worked some of that stuff out. They have figured out where they have some shared interests, and they figured out what interests they really need to deal with maybe at the more regional level and not claim universal applicability. At the end of the Cold War, early 1990s, what happens is that the international community, and the UN in particular, recognize that now with the end of the Cold War system, there's a new opportunity for the international community to rethink human rights law, to rethink international humanitarian law. Certain things have been kind of frozen because of the Cold War. There's now a kind of an unlocking. There's an opportunity to rethink all of this. And the UN basically holds a major conference on human rights in 1993 in Vienna. This conference is in planning for a couple of years, but as it happens, by the time the conference actually starts in June of 1993, word is out about systematic rapes in the former Yugoslavia. Okay, that news starts to emerge in the spring of 1993. Very shortly after the conference, news starts to emerge from the Rwandan genocide about the systematic use of sexual violence as well. So this human rights conference happens at this moment of a kind of an opening up because of the end of the Cold War, but also a recognition that the end of the Cold War is going to mean new wars at the regional level. Maybe not world wars, but there are going to be these regional wars. At least that's how things look. So again, war becomes the backdrop for this effort to rethink human rights. This influences international feminists as well. International feminists basically plan with this 1993 conference on human rights in Vienna. They sort of hold a conference kind of right at the hotel next door, so to speak. And this is an old trick of feminists. They did it with the League of Nations. They did it with the founding of the UN. You've got a big UN conference. They're going to be talking about something. We're going to have a feminist conference in the same city at the same time. That way we get the media. That way we can go back and forth. We can have conversations that go between the two. So they basically have this very, very important tribunal on women's human rights in Vienna, parallel with this. And because of this sort of fraught nature of North-South relations, but now the end of the Cold War, they end up focusing on something that everybody can agree on in the international community, international feminist community, and that is that there's an awful lot of violence against women, and that this is not a good thing. And what happens in this very, very important conference in June of 1993, the Tribunal on Women's Human Rights, is that they put on stage systematic sexual violence against women in warfare. It's in the news right now. But in addition, at the same time, there's a lot of former comfort women, Korean women who had been held as sexual slaves in the Asian theater in World War II are now reaching old age, and some of them are starting to speak up. So there's sort of a sense of the historical nature of this problem. They have that big discussion going on, and at the same time, they're having discussions about violence against women in non-conflict settings, intimate partner violence. Okay? Sexual violence, systematic sexual violence against women in the workplace, domestic servants, for example, agricultural workers who are vulnerable to systematic sexual violence. And they're putting these things on stage at the same time. What they're doing here, a lot of very interesting things happen in this conference, and there's wonderful documentation that I highly recommend for teaching this area. It's really good stuff, the testimony that these women give. But for our purposes, what's really important is that they are basically challenging this divide between armed conflict over here and non-conflict settings over here as two completely different worlds. They're basically establishing violence against women as something that is just pervasive in all areas of life. It takes different forms. It might have different levels of intensity, but the human beings who are involved in it, both as perpetrators, as victims, as bystanders, are the same people. They're experiencing this in peacetime, and then their country goes to war, and then it's happening in war. Okay? Some of the same factors that make it endemic apply to so-called peace and to war. So they're really challenging this distinction between peace and war, which institutionally had been anchored in the international humanitarian law, human rights law distinction. And it also more sort of theoretically had been anchored in the association of citizenship with armed conflict and the privileging of armed conflict as a place for citizenship claims. So this is not just a matter of sort of bringing new issues to the table. This is a fundamental critique of the foundations of human rights law and humanitarian law, the basic frameworks there, and the insistence on a kind of continuum. In the aftermath of the Vienna conference, and these are really powerful minds at work. It's impressive to read their analyses. And some of these are feminist lawyers with decades of experience by this time. They really know their way around this material. And they continue then to work within these institutions and on the outside of the institutions to try to get change. Where that eventually leaves us, however, is with the contrast I described in the beginning, a sense a couple decades later of much more progress, at least in the legal arena, in the world of armed conflict than in the world of sort of non-armed conflict situations. International feminists, legal advocates' challenge was essentially to change the language and change conceptions of sexual violence to encompass both, and also to make clear across the board that women are rights-bearing subjects, okay? Get rid of this protective framework. Make clear that sexual violence against women is not an insult to somebody's honor, but it's a bodily injury, okay? And that was a very hard thing for a lot of people to wrap their minds around, that sexual violence is a bodily injury. It was, it took a very, very long time to push that through, but some very, very powerful work was done. In terms of where we are now, we have a situation where the argument for women's full citizenship as rights-bearing subjects clearly has anchored itself when it comes to war crimes, right? Again, this is sort of the foundation of the International Criminal Court and the Rome statutes that I told you about. This notion of women as rights-bearing subjects, violence against them is violence against them. It's physical violence, it's against their bodies, and they have a right not to be subjected to violence. And that proved very compelling somehow in the arena of developing legal frameworks for how war should be conducted and what kind of activity was prohibited even in war. Less success in the arena of human rights. There's a much shorter tradition of human rights law and international law, obviously, and less of a tradition of dealing with violence of any kind in human rights law. The most important area where human rights law had dealt with violence had to do with violence inflicted by the state. Okay? The state should not torture political prisoners, for example. Right? A big tradition of that in human rights law. When it came to violence in the so-called private sphere, however, this was something that human rights law had dealt very awkwardly with. What we see now is a very, very important insight articulated very well, in this sort of paradigmatic way in 1993, a very important insight about the continuum of violence against women between peacetime and wartime settings. But when it comes to implementation or even the formation of law, this separation between international humanitarian law and human rights law has proven pretty stubborn in a lot of ways. And at the same time, the kind of linking of citizenship claims to war has meant that where women have been able to make that kind of convincing claim to full citizenship, they've been able to make a more convincing claim to full citizenship when it comes to how they're treated in war, right, to the participation in war. And it's been harder to make that claim to full citizenship rights outside the arena of war. So what we're hoping to sort of provide by this discussion is a sense of the kind of historical durability of the sort of gender citizenship war framework and how durable that framework is, and then how that then finds its way into the legal frameworks that all of our colleagues who are working very much in present-day circumstances are dealing with, that this isn't just an accident of what law happens to be where, but there's this foundational problem of citizenship and war that makes gender a difficult fit. We see a kind of a danger that the insight of continuity between armed conflict and non-armed conflict situation, that insight fades away in light of the power of two distinct traditions of international law, but also that insight fades away in light of the even longer tradition of privileging citizenship claims that can attach themselves to the arena of armed conflict. So I'd very much welcome questions and discussion. I know that members of the audience here are coming to this subject probably from a lot of disciplinary perspectives, and that's exactly what we're hoping to speak to in this larger interdisciplinary project regarding violence against women. So thank you.